Appointments to the federal courts in many ways will determine the extent to which judges are receptive to an expanded view of antitrust enforcement. And President Biden, through September, mid-September, has appointed about 140 members of the federal courts at this point. Judges have been confirmed. 36 of those are in the courts of appeals, 104 in the federal district courts. He's appointed a more diverse bench. He's appointed individuals who, by professional background, don't simply come from big law firms. They come from another number of other backgrounds. What is interesting is that he has not chosen academics yet. He's not picked academics who would be more likely to immediately be able to affect the development of doctrine by writing opinions that would push antitrust enforcement outward from its relatively narrow core today. In other words, he hasn't followed the strategy that Ronald Reagan used very successfully from 1981 to 1988 to pick academics who would come with an intellectual vision about what economic regulation should look like. The initiatives of the two agencies also will have to convince a relatively skeptical Supreme Court that does not completely oppose the idea of antitrust enforcement, but has a relatively narrow view of what it should be. The FTC in particular has discovered recently that the court is skeptical about inferring broad grants of authority from statutes that do not clearly state that the authority of the agency is present to carry out certain tasks. The court almost certainly will be receiving cases over the next few years that re-engage the government in arguing monopolization cases, re-engage the court in deciding merger policy. As the court does this, it will be skeptical, but it's not completely nihilistic. There are some bright signs for government plaintiffs that the court might be receptive to certain arguments. Thank you.